case briefs, and so much more. LSData's got what you're looking for.
An embattled paint manufacturer found itself on the losing end of a landmark 1974 legal dispute known as G.O.C. Christopher & Son, Inc. v. Kansas Paint and Color Company, heard by the Kansas Supreme Court. The heart of the case lay in the interpretation of the Uniform Commercial Code's rules relating to sales, particularly the validity of disclaimers excluding implied warranties of fitness. The plaintiff, a structural steel fabricating company, sued the paint manufacturer following a catastrophic failure of the defendant's primer, which turned an ordinary Air Force Base construction project into a rusting debacle. The relationship between the two companies was a long-standing one, emphasized by the fact that the plaintiff had been sourcing primer from the defendant for years. However, things took a wrong turn when Penner Construction Company sought the plaintiff's partnership for a hangar project at Altus Air Force Base. The plaintiff requested a specific paint from the defendant. Upon being told that the specifications for the paint were unmet, the plaintiff asked the defendant to develop a formula, which could then be sent to various manufacturers for bidding. In response, the paint manufacturer placed its faith in a disclaimer that was supposed to excuse it from responsibility for its non-standard primer. At the trial court, however, it was determined that the binding contract between the two companies could not be modified by a disclaimer. The court deemed the disclaimer as subpar, both in terms of its visibility and its inability to exclude the implied warranty of fitness. Upon appeal, the court endorsed the lower court's verdict, maintaining that a valid contract had indeed been violated. The paint manufacturer was found to have breached the warranty of fitness by supplying inferior paint. As a result, the disclaimer was rendered toothless, and the defendant's frustration compounded as the court upheld the trial court's decision to reject the motion for a new trial over claims of juror misconduct. The ruling underlined the significance of clear and conspicuous disclaimers and the invulnerability of the implied warranty of fitness to such disclaimers. It also emphasized the court's stringent approach to claims of juror misconduct. In essence, the killer blow from the courts left Kansas Paint and Color Company licking their wounds and the judge's inkwell dry.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.